Hi, I'm Michael Hughes, and this is Contract Mastery. Paragraph 22 of the lease agreement talks about holdover tenants and holdover tenancies. These are tenants who have essentially overstayed the lease. The lease is over, and yet they are still there. So a holdover tenant is defined as a tenant who took possession of the property legally under a valid lease, but the term of the lease has expired and the tenant has not yet surrendered the property. They are holding over. This is different from what happens when the lease agreement automatically renews on a month-to-month basis. That's provided for in the lease agreement. That's a periodic tenancy, and that's different than what we're talking about here. With a holdover, we're talking about a tenant who no longer has any right to possess the property, and yet they have not given the property back. They're still there. Under paragraph 22, if the tenant fails to vacate the property at the time this lease ends, the tenant will pay landlord rent for the holdover period and will indemnify the landlord and any prospective tenants for damages, including but not limited to lost rent, lodging expenses, costs of eviction, and attorney fees. Rent for any holdover period will be 3 times the monthly rent, calculated on a daily basis, and will be immediately due and payable daily without notice or demand. Once the tenant holds over, their rent triples on a day-to-day basis, and there is no further consent, agreement, or signature required from the tenant for that rent increase to take effect in a holdover situation. Notice also in paragraph 22 that the holdover tenant is required to indemnify not only the landlord, but any other prospective tenant. So if by their holding over, the prospective tenant is not able to move in to the property and they incur expenses for hotel rooms or storing their property while the landlord is working to get the holdover tenants out of the property, then the holdover is required to indemnify the prospective tenants as well as the landlord. Paragraph 23 talks about the residential landlord's lien. A lot of people don't really know this, that when there is a residential tenancy, the landlord has a lien on some of the tenant's personal property located on the rental premises. The lease agreement provides that the landlord with a lien against the tenant's non-exempt personal property in the rental unit. Now, landlords need to be careful with this paragraph. They need to consult an attorney if they're going to try to avail themselves of this landlord's residential lien. Only certain property is subject to the lien. It has to be non-exempt property. And there are strict requirements in the property code on how to remove and store the tenant's personal property. It's not just a free-for-all. I have known of some landlords who would refer to this as lockout shopping, where they would just go in and help themselves to the tenant's property. That's not permitted, and a landlord can get themselves into trouble for doing that. So if they want to take advantage of this paragraph 23, the landlords really do need to consult an attorney. Landlord will have a lien for unpaid rent against all of tenant's non-exempt personal property that is in the property and may seize such non-exempt property if tenant fails to pay the rent. The property code governs the rights and obligations of the parties regarding the landlord's lien. The landlord may collect a charge for packing, removing, and storing property seized in addition to any other amounts landlord is entitled to receive under the lease agreement. Landlord may sell or dispose of any seized property in accordance with the provisions of Section 54.045 of the Texas Property Code. One thing, however, it's important to understand is none of the provisions of the property code allow the landlord to just take the tenant's property and keep it for themselves. They have to follow the procedures in the property code.